Good morning, everyone. I hope everyone is doing well today. Welcome. My name is Valentina Kova. I am the communications manager here at Ontario One Call. Thank you so much for joining us today for our final quarterly compliance and industry performance webinar of 2023. While we wait a couple more minutes for everyone to settle in, I just would like to let everyone know that we are recording this webinar and we will send out the recording in the next couple of days. Also, you are welcome to send us your questions at any point during this presentation by using the Q&A button at the top of your screen. We will address all the questions at the end of the presentation, and in case we get more questions than time allows, please feel free to get in touch with us at cape@ontarioonecall.ca. That would be CAIP@ontarioonecall.ca. So welcome again today for our quarterly compliance and industry performance webinar. We have a packed agenda. So I would like to welcome Ryan McAfee, Director of Compliance and Industry Performance here at Ontario One Call. Hi, Ryan.
Good morning, Valentina. Thank you for the introduction. And thank you everyone for joining us today. We have guests from the infrastructure owner, excavator, and locator industries. We also have guests joining us today from government as well as Ontario One Call and throughout the sector, really. So welcome everyone. Thank you for joining us for our last webinar of the year. And I'd like to introduce our panel, although they'll be turning their cameras on a little bit later on in the presentation. So first, I'd like to introduce Keegan Arnott, our compliance administrator, who put this entire webinar together. So Keegan, thank you very much for your efforts. Thank you. There you are. So our guest today may have had some back and forth with Keegan, perhaps even submitting questions ahead of time. So thank you for that if you did. In a moment, I'll be introducing Corey Officer, the Supervisor of Compliance and Industry Performance, who will be sharing some information with you about year-end compliance data throughout the sector. And we also have, we're also joined today by Jean Lepin, our Chief Corporate Officer, who is also the executive lead of the compliance function here at Ontario One Call. So let me advance our deck. Oh, here we go. All right, so here's our agenda for today. We're starting with a compliance update. So Corey will be joining us for a moment for that. And then I'll be spending some time with you after Corey's presentation. We'll be reviewing Ontario One Call's dispute resolution framework. We'll then move on to Jean's presentation, which will be legislative updates. And then the entire panel will come together at the end of the webinar for the Q&A portion. And so if you have questions, as Valentina mentioned, please go ahead and ask. So we'll start with the compliance update presented by Corey Officer. Corey, why don't you join us?
Hello, everyone. Good morning. Happy to be here with all of you today. Thank you, Ryan. Thanks for joining. I am going to be going over some compliance stats, everything from the locate delivery performance to complaints and investigations. So Ryan, why don't we go next slide? So starting with the locate delivery performance, this slide on the left-hand side is showing the member perspective. This is the number of locates that are completed individually, so by the infrastructure owner. And the right side is the excavator perspective. So this is when all locates are completed within a full complete package so that excavators can proceed with excavation. So they're quite similar in the 11 to 15 and 16 plus buckets this year, which is great. In for the member perspective, they are 85% on time, and for excavators is 73. So there's about a 12% difference there. That 12% for the excavator perspective is kind of trickles into the 6 to 10 bucket. This is very different compared to 2022. In 2022, the excavator perspective was actually 43% on time, so the 0 to 5 days, which is the legislated time frame. And that is a 34% improvement in performance. So across the province, year to date, we are seeing that excavators are receiving their total locate package completed by all members with 34%, with a 34% improvement compared to last year. Ryan, next slide. So this graph here is showing our complaint data. So this is the number of complaints that have come into the compliance department every year for the last 3 years. And 2023 was very consistent with 2022 all the way until June. And then we started to see complaints die off a little bit from July until November. We don't have full December data yet, but this, I believe, is directly attributed to the increase in compliant performance. Something that I would like to touch on this slide quickly, just in my speaking notes, is I'd like to talk about the different types of inquiries and complaints that come into the compliance department and how we reach out. So there are many different inquiries that come into the compliance team. Every complaint that comes in through the online complaint portal is vetted and triaged by one of our staff, and we reach out 3 different ways. So in the subject line of the email that you would receive, whether you're an excavator or a member, infrastructure owner, the subject line would read either case, complaint, or investigation, along with a number, a unique number for that scenario. So if it's a case, if it says case, it's us reaching out informally. These are not recorded. It's strictly an administrative matter or a customer service reach out. A good example of this would be, let's say an excavator reached out to us about missing paperwork. We don't record those as a complaint. We try to reach out and handle that without a formal complaint. So the next one would be a complaint in the subject line. Those are reviewed, like I said, by the staff, and we vet those before we reach out. So we review the 360 feedback to ensure that the member has filled out that within the 3 business days, and then we go from there. So those are recorded, tracked, and included on this slide right here. And then finally, investigations. So most investigations start as a complaint, and then they're escalated to an investigation. They are also included on this slide. Most investigations are more serious contraventions, like involving public safety. Those do go directly to an investigation, like excavation without locates, and those are tracked as well. Thank you, Ryan. Next slide. So this is more just seeing the last slide in numbers. So year to date, we have received a total of 1,900 complaints, formal complaints. Those are formal reach outs. So the informal reach outs that we do are not included in this data. And 90% of the complaints that we received were about late locates. If you compare this to previous years in 2022, 2021, you would see that the percentage is a little bit lower for late locates this year. That is because we have focused on 4 key areas that we committed to at the beginning of 2023, which I'll talk about a little bit later. But complaints are down by 32% this year. Ryan, next slide. So this is our complaint data by region. So like I said, 32% decrease in complaints this year. And by region, we that there were 4 regions within the province that had an increase this year, even with the 32% decrease in complaints. So Chatham, Essex, London, St. Thomas, Ontario Central, and Ontario Southeast all had an increase in complaints this year. Next slide. Thank you. So, like I mentioned previously, we committed to 4 key areas to focus on in 2023, and those 4 key areas are excavation without locates, also expired locates or excavation in an unsafe manner. The second was priority projects, and third was late locates, and then finally ticket dumping. So this is our investigative efforts in 2023. That's what this pie chart shows. And 55% of our investigations were focused on excavation without locates, expired locates, or excavation in an unsafe manner. Some of the investigations that would fall in the other category would be delinquent accounts, emergency locate abuse, inaccurate locates, um, and that worked out to about 24%. Ryan, if you could go next slide. So 77% of our investigative efforts were focused on those 4 areas. And as you can see here, it's just itemized a little bit more. So 12% was focused on ticket dumping and 6 were focused on late locates. Now, most of the late locate matters that come to compliance are dealt with through complaints. This 6% or 8 investigations that we did this year are matters that were escalated beyond a complaint because they were not resolved within a timely manner. So and then finally, failure to comply with dedicated locator provisions. That is something very new to the CAPE team that we, like I said, committed to, and that would fall under the priority projects key area. So that's it for me. Thank you for your time, and like Ryan mentioned, please submit your questions in the Q&A function, and we will circle back at the end of the webinar. Thank you.
Thank you for that, Corey. And apologies, I have a bit of a delay on my presentation here. So I have a feeling this is going to persist through the rest of the presentation. Patience, please, as we move forward. So let's move on to the next portion of the presentation, which is the dispute resolution framework. So I want to start by saying that, to be transparent, it was a challenge to put this portion of the presentation together because at times it felt incongruous with the messages about collaboration that you've been hearing from us all through the year. So as we go through this section, please bear in mind that we're sharing this information with you today because we think it's important for you to know, but there's nothing that you're about to hear that changes the compliance and industry performance teams or CAPE's view that our role includes being supportive and collaborative as we do our work. In fact, as we talk about our investigations, sometimes it's the worst case scenario, and we know, especially based on the presentation that Corey just provided, that there's reason for optimism in our community. There's been a marked improvement in locate performance throughout the province throughout the year. So with that in mind, we'll get into the first slide. If the presentation will cooperate with me. Okay. So Ontario One Call's dispute resolution policy, it is available on our website, depicted here. It sets out the way that disputes will be addressed in a manner that balances efficiency, fairness, cost to effective members and excavators, as well as the cost to Ontario One Call. Now, the administrative penalty regulation and the AP framework has really dominated the conversation over the course of the last year, perhaps even longer, when it comes to what the possible outcomes would be of a compliance investigation or another intervention at Ontario One Call. So we want to share this information with you today about the dispute resolution policy because, well, really for a number of reasons. Well, first of all, it's important to know about the dispute resolution process because it's our current process. And even when the administrative penalty regulation rolls back into force in the spring, the dispute resolution process will still exist. And also, we want you to be aware of your obligations and your rights under Ontario's Not-for-Profit Corporations Act, or ONCA. And because the result of matters that flow through the dispute resolution framework can be impactful for your businesses, where Ontario One Call issues an outcome that's either disciplinary or non-disciplinary in nature. There's a lot to the policy. I encourage you to review it and let us know if you'd like to learn more. We can set up one-on-ones. We've been doing that a lot this year. We can even have a follow-up webinar. Not to muddy the waters, but just to touch on the administrative penalty regulation for a moment before we move on, is that we know that we need to do some more communicating about the administrative penalty regulation before it rolls into force. So that will be the topic of a webinar early next year. The dispute resolution policy sets out two distinct pathways. Option one, which involves an application to the court under the Not-for-Profit Corporations Act, and option two, which is the private dispute resolution where the aggrieved party is a member, an excavator, or Ontario One Call. But we can't have that conversation without first talking a little bit about the investigative process. So our investigations broadly fall into two categories, reactive investigations and proactive investigations. So a reactive investigation has a trigger that's external to Ontario One Call. So for instance, this could be a late locate complaint where a resolution wasn't reached between parties, whereas a proactive investigation would have a trigger that's internal to Ontario One Call. So that trigger is, well, it's usually data. So for instance, CAPE triggered several 360 feedback cases right at the end of this year when our data showed that certain members were not meeting their obligations to provide 360 feedback. So cases that can't be resolved through an early intervention would be escalated to investigation. A note here, and something that I think is important to highlight in today's webinar, is that Ontario One Call is always going to try to resolve complaints at the earliest stage possible. So Keegan and his colleagues, Soleil and Isabella, who you will have had interactions with if you've been to our previous webinars, there are early intervention teams. And in most cases, complaints can be resolved through early intervention and not need to be escalated to investigation. But regardless of the type of investigation or the trigger of the investigation, there's a variety of outcomes that we'll talk about in the next slide. Okay, so we're going to spend a little bit of time on this slide to describe each of the possible investigation outcomes because it's important to understand the difference between disciplinary and non-disciplinary outcomes to navigate the dispute resolution process. So let's then start with non-disciplinary outcomes, so the column on the left. No further action means, well, not all matters, first of all, that escalate to investigation require an investigation. So for example, where there's a mistaken fact or the complainant has abandoned their complaint and is no longer communicating with us, CAPE will likely take no further action. So a proportion of our investigations are closed with no further action. Warning letters, on the other hand, are the most common investigative outcome where the investigation was substantiated either in whole or in part. Now, unlike a reprimand, which we'll talk about in a moment, a warning letter is non-disciplinary. Our warning letters provide guidance to members and excavators regarding the consequences of further noncompliance. The educational disposition, I think, is really an important one to talk about. It's an outcome where an investigator provides the member or excavator with written guidance, including a requirement to take a particular education course at the member or excavator's own expense. So, earlier this year, an education disposition required an excavator to take No Risk, which is an Ontario One Call offering built in-house by our training and development team. to provide the excavator with the knowledge that they need to safely meet their obligations in the future when an investigation revealed non-compliance related to unsafe practices. Moving on to a negotiated resolution. So this could essentially be anything that Ontario One Call and the party subject to the investigation agree to, as opposed to an outcome imposed by Ontario One Call. So while we haven't had a negotiated resolution yet, I can envision a scenario where, for instance, a member agrees to change a practice that would improve safety where an investigation revealed a safety shortfall. And then other. So other is an outcome that permits Ontario One Call to take such other steps that we deem necessary and appropriate that are consistent with the One Call Act, with our bylaws, or with rules. So this outcome varies by the circumstances, but one example that comes to mind is a case where a member or excavator is subject to investigation from another regulatory body, by a law enforcement organization, or perhaps a ministry, where Ontario One Call wishes to not take any further action until those other matters are first resolved. And there's some reasons and investigative best practices to do that. So we'll move on to the disciplinary investigative outcomes. So first off, Ontario One Call may refer matters elsewhere, such as to the TSSA, ESA, Ministry of Labor, and elsewhere. This is an outcome where we consider in varying circumstances, including in cases where the party subject to the investigation hasn't acted to protect the public from harm, and there's an ongoing risk to community safety where a regulatory partner has authority to take action. So for instance, we might escalate or refer a matter to the TSSA in those cases. Change in internal process is an outcome that can have lasting operational and financial impacts for members and excavators. For instance, earlier this year, one of our investigators issued a disciplinary action that required a severely non-compliant member, a member whose conduct was very poor. In fact, they weren't responding to any locate requests. So this outcome required the member to employ or to contract out competent staff to comply with their locating obligations under the Act. And then finally, a reprimand is a written disciplinary action that remains on the member or excavator's Ontario One Call file and impacts future decision making. And I'll just speak for a moment on reprimand to remind the audience of our risk matrix that takes the severity of the issue into consideration, but it also takes conduct or the obligated party's history of good conduct into consideration when deciding the next steps that an investigator may take. When parties are subject to investigative outcome, they'll always be advised of the steps that they need to take in order to achieve compliance. Our team has an approvals framework that includes management sign-off before disciplinary and non-disciplinary actions are taken. And as always, our decisions and actions are guided by the Code of Conduct for Ontario One Call compliance personnel, meaning that you can expect us to do our work with honesty and with integrity. And you can find a copy of the Compliance Code of Conduct on our website. Okay. So now onto the dispute resolution process. Now that we've had this information about the investigative process, so your right to access dispute resolution. Now, following an investigation, if you agree with an outcome and decide not to take any further action, the process ends there. CAPE will continue to support you in achieving compliance. Even if you elect to take further action, we'll still support you in achieving compliance. That's what our program's about. Now, I mentioned earlier that the dispute resolution policy includes two distinct pathways, and I think the policy is more easily navigated when starting with option 2. So this slide depicts option 2, which is the private dispute resolution. We'll move on to option 1 in the next slide. There is a summary slide to come, so don't worry about missing nuance as we go, because like I said, you can also view the policy online, which is available for your review. You have the right to dispute an outcome that's either disciplinary or non-disciplinary through option 2. Now, within 10 calendar days of receiving Ontario One Call's decision, Following a compliance investigation, the member or the excavator subject to a disciplinary or non-disciplinary outcome can initiate a dispute resolution by sending an email to us at dispute@ontariooncall.ca with a subject line, notice of dispute, the case number, as well as the member's name. The exceptions for this process are the administrative penalties regulation, so those are handled through the AP policy, also on our website, as well as take no further action, because essentially when OneCall takes no further action, there isn't a dispute to resolve. So when emailing us, summarize the nature of the dispute, the key facts, submit supporting documents, and tell us the outcome that you're looking for. Next, within 10 calendar days of receiving the notice of dispute, Ontario OneCall will arrange for a management meeting with the aggrieved party. Now, both parties must work together, making our best efforts to schedule the meeting with management representatives from both sides. The purpose of the meeting is to attempt to resolve the dispute. If the aggrieved party has issues that remain unresolved following the management discussion and they wish to pursue the matter further, they can do so, and they can do so within 10 calendar days of the management discussion. How that process works is that the aggrieved party would advise Ontario OneCall of the escalation to arbitration by sending a notice to arbitrate to us via email. Same email address, dispute@ontariooncall.ca, with the subject line arbitration and the case ID. In your notice, summarize the concerns that remain outstanding following the management discussion and provide all documentation in support of those concerns, including submitting information or documentation requested by Ontario OneCall. As we move into the arbitration process, we're required to equally share the cost of the arbitration, regardless of the outcome of the arbitration. So bearing that in mind, at this stage, the aggrieved party must, either by courier or by regular mail, provide Ontario OneCall with a deposit check in the amount of $2,500, which will be held by Ontario OneCall and will be used to pay for the first $2,500 of the member or excavator's share of the arbitration fees. Now, if the, of course, we would return that check of $2,500 if the member or excavator decide to abandon the arbitration before any fees are incurred by the arbitrator. And if fees are incurred by the arbitrator, of course, we will split those fees equally. So at this stage, we participate in the arbitration. So within 10 days of the receipt of the aggrieved party's notice to arbitrate, we must together choose an arbitrator from the roster of arbitrators at ADR Chambers. Now that's a business entity operating in Toronto. And unless the parties and the arbitrator agree otherwise, an arbitration lasting no more than 1 day will be scheduled to take place on a mutually convenient date that's no later than 2 months from the date of the notice to arbitrate. So then the question is, well, what happens at the arbitration? Well, first of all, both parties, both Ontario OneCall and the aggrieved party, we divide the time equally to present our positions to the arbitrator, which means in the case of a 1-day arbitration, both parties would have 1 half day to present their case. Both parties may call witnesses under oath, examine, cross-examine, and re-examine those witnesses. We would make submissions to the arbitrator, as well as submit any documentary evidence and other evidence to the arbitrator for their consideration. An important note here is that the arbitrator's decision is final and binding, and that decision can be enforced as an order of the court if necessary. So let's move on to the next slide. This slide depicts, it summarizes option 1 in the dispute resolution process and how a court application made under the Not-for-Profit Corporations Act can be triggered where the aggrieved party is a member and not an excavator unless the excavator is also a member. A management discussion is also an option within this process. The member may, but is not required to, request a management discussion in keeping with the process described in the previous slide within 10 calendar days of receiving Ontario OneCall's decision by emailing dispute@ontariooncall.ca to try to resolve the dispute before proceeding with a court application. Now, the court process can be triggered by a member when a member when a compliance investigation results in one or more of the disciplinary outcomes I mentioned a few slides back. So that's refer elsewhere, requiring the member to change internal processes, or if a reprimand is issued. So in this framework, a member seeks the court's assistance where the member is aggrieved and believes that Ontario One Call has not acted in accordance with its governance and taking disciplinary action. For instance, a member might decide to file an application with the court if it believes Ontario One Call contravened one or more of our organizational bylaws. So here's the summary table that I mentioned a moment ago. It's a convenient summary broken down from disciplinary and non-disciplinary outcomes and by court application versus private dispute resolution. So as you can see here, no further action is not included in either of these processes because essentially, if one call hasn't taken any action, there's no dispute to resolve. And the administrative penalty regulation, or pardon me, administrative penalties are also not included in these processes because they're handled by Ontario One Call's administrative penalty policy, which, yes, available on our website, but important takeaway is that administrative penalties can be appealed through the Ontario Land Tribunal and not through arbitration or court application made under the Not-for-Profit Corporations Act. Now, because of the way that the Not-for-Profit Corporation Act operates, only members of Ontario One Call can file an application with the court. So you see here that excavators don't have a pathway through option 1, while they do have access to dispute resolution through option 2. And as I mentioned, there's a difference where the member is also an excavator. Now, I'll wrap this section by saying our goal is to support the community as we work to achieve compliance. And yes, we try to resolve every complaint at the earliest stage possible. But there are times and there are occasions when Ontario One Call has to take disciplinary or non-disciplinary action in order to do our job as a public safety administrative authority. And when we do, you can count on us to do our work with integrity. So that wraps the dispute resolution portion of the presentation. Like I said, we will be available for questions following the next section, but I welcome Jean Lepine to join us for the next section.
Thank you, Ryan. And thank you to everyone. I mean, I've been watching, obviously enthralled with Ryan's work and Corey's work and their presentation skills, but I was watching the ticker to see how many folks were on, and you know, for 120 people to participate on a December 14th webinar it's impressive. And it's in part, I wanted to say at the beginning, thank you to all the folks who made the time to join us today. My section in this is very short, so I wanted to say thank you in advance, and also to say thank you to the team, because the CAPE team is newish. You know, it's building its capability, and very proud of the work that they're doing. We set a goal for the team at the beginning of the year, or management did. So, you know, you need to get out there and communicate very clearly what we're doing in compliance and how we intend to collaborate with the industry on a go-forward basis. And to be good collaborators, you have to communicate clearly, and I think Ryan and the team are doing that. But I would love to get feedback, or we would love to get feedback. I think we generally send out surveys at the end, but we'd love to get your feedback on how we're doing, because, you know, if we can improve, we will. And so with your feedback, I think we can get there. So thank you for finding the time to see us. Thank you for continuing to be focused on this important work. And thank you for giving us the opportunity to share with you a few thoughts. My role is to talk you through, or at least share with you, some bits of Bill 153, which is the Building Infrastructure Safely Act. And it's an act to amend our underlying act, commonly known as the Underground Infrastructure Act. So when you look at these four bits here that are a part of the legislation that's now through second reading and would in theory go to committee in the new year. You've got 4 elements, one being no charging for locate. So currently the Act prohibits one call for charging a person submitting a locate request, but it does not explicitly authorize or prohibit underground infrastructure owners or operators from charging for delivering locates. So if passed, this change would ensure that infrastructure owners are prohibited from charging excavators or the public for the provision of locates, which would minimize any public safety risks and align with the longstanding industry practice in Canada and the US that locates are provided free of charge. In terms of the second, no excavator recourse, removing that recourse provision in the section of the Act at 17(1)(c) that entitles excavators to compensation and seek recourse through the Ontario Land Tribunal against underground infrastructure owners or operators for failing to provide a locate within the legislated time limit. This provision was added to the Act in 2022. However, there are mechanisms, as you know, in place to hold members accountable for meeting the timelines, such as administrative penalties, which will come into effect in the spring of 2024. The third bullet being Ontario One Call's alignment with other public safety administrative authorities and the tools that they have. So this section of the legislation that is available online that you can go look at is to align certain One Call powers and responsibilities with other administrative authorities in key areas. And those are giving us the explicit authority to charge and collect fees. Believe it or not, it wasn't in our Act previously. For us to charge fees and collect fees from members and project owners. And that's similar to other administrative authorities. And to allow the Minister of Public and Business Service Delivery to specify additional objects for One Call, which that's very similar to the TSSA, and additional objects are just, pursuits of the organization. And finally, and this exists across all the administrative authorities, it provides protections for our officers, directors, employees, and agents from personal liability. The last bullet is providing the minister with regulation making powers. I mean, this just gives the minister powers on further amendments to implement proposals. So when they go out, when the ministry goes out and consults with industry and others, there are always actions that or generally there are actions that come out of those consultations, and this gives them the power to act on things that they find important and that are part of the government's agenda. This is in addition to other proposals the ministry is working on in response to the consultations that I just mentioned. And a draft regulatory proposal to provide a longer locate timeline for large projects under the One Call Act. So that regulatory registry posting is now has been up and comments have been received. I'm hopeful that you had the opportunity to provide your commentary if you so chose, but that was up. It affected, there was a proposal for a 10-day time limit for large excavation projects, and so that's happening. The ministry is taking feedback, the submissions that were made, and will go forward with its work in the new year. Brian, if you don't mind, we could go to the next slide. So there has been a bunch of work done, as I said, regulatory registry posting that's occurred. There is a new regulatory registry posting now on the legislation that is now up and available for you to review. We encourage you, as we encourage everyone, to make comments known to the ministry. I think you have until December 22nd to do that on this particular piece of legislation. And we're always happy to receive a copy of the feedback if you so choose, but otherwise, provide it directly to the ministry. Our goal, again, is to always work in collaboration with the community, as Ryan calls the regulated community. So we will look for ways to work together. We will be fair and we will be promoting better performance as best we can. We don't have all the levers, unfortunately, but we do have willingness, and we've got a positive group of folks who are trying to do good on a day-to-day basis, just as you are. And we look forward to continued collaboration in the months and years to come. Thank you.
All right, thanks very much for Jean. So I've stopped sharing the deck, and I'll ask Keegan and Corey to join us for the Q&A session. Jean's still with us. So this is your time. Keegan, over to you. Do we have any questions posed by the audience?
Yes, we actually have a few good questions here, so I'll just get to it. Thank you for submitting all your questions, and they're all great questions. First one I have here is in regards to the excavator's perspective for all locates being compliant, does the 0 to 5 day include the renegotiated dates that are actually allowing the locators to deliver an on-time locate, but beyond the legislated 5 business days?
Oh, that is a great question. I'll hand over to Corey to answer the one from his section.
Sure. Yes, so it all depends on when you renegotiate the request. So if you're renegotiating the request before the work to begin date or the due date, let's say, the clock is kind of pauses in a way. And then once it gets, let's say there's 5 days to complete the locate. Let's say it's renegotiated on day 2. So then you now have up to 3 business days before the renegotiated date to complete it. If it's renegotiated after the work to begin date, that will not be included in the 0 to 5 bucket. It is already not compliant.
If I can just, if I add a little bit to Corey's, that was great. Thank you, Corey. I would say that just my lived experience over the last year, some guidance that we tend to give as well is to please bear in mind that when it comes to renegotiating, to keep that renegotiating can happen lawfully, but do your due diligence. So do keep records. Bear in mind that both parties must agree to a different timeline. So please do keep good records of that.
All right, thank you, Corey and Ryan. Next question we have here, is there any engagement between Ontario One Call and a member in advance of issuing a warning letter?
Yes, so I'll take that one. The warning letter is the outcome of the investigation. So we would have started with a notice of investigation earlier on, and if it is, let me start by saying, I'll backtrack for a moment, that public safety contraventions of the Act, so digging without locates, digging in an unsafe manner, those issues go directly to one of our investigators to issue a notice of investigation and to begin the investigation process, because we view this as high risk to the public and to our own community as well. Other matters that come into to CAPE, so the lion's share, of course, being late locates, would be resolved by hopefully by the early intervention team, so Keegan and his colleagues. But there is, through our investigative process, members and excavators always have a voice and always have the opportunity to respond to allegations and to have a conversation with our investigators. So yes, no one will receive any outcome as a surprise. That the process will always have unfolded, and then the outcome, whether it's disciplinary or non-disciplinary, is just that. It's an outcome.
Excellent. Thank you, Ryan, for that. All right. Third question. Is there a freedom of information type process whereby the member can request records from Ontario One Call?
Yes, so members can request their own records. We do have a privacy policy, which is quite involved, but essentially it tells Ontario One Call when it is that we can share information. There are times when we are required to share information. For instance, under our statute, we're required to post member locate performance. So you'll find that on our website. But if members would like more visibility to their data, if they have questions, especially if they have compliance questions, please do reach out to us at CAPE and we'll help facilitate that.
Perfect.
And I'm just noticing that we're at time now, but if the panel agrees, could we go over a few more minutes to see if we can get a couple more questions in? Yes. I've now made it impossible for Jean to say no. So perhaps another couple questions since we went a little bit over in the presentation side.
Sure, I have two great ones here. All right, so first one I have is the dispute process to deal with disciplinary decisions or other notice types, i.e. warning letters, that kind of thing.
Yeah, so under the dispute resolution process, there are two types of outcomes. So there are disciplinary and non-disciplinary outcomes. Through option 2, disputes can be handled for either non-disciplinary or disciplinary. So if a member or excavator disagrees with the action that we've taken, they have an opportunity to dispute those. And then the court application, because of the way that ONCA, the Non-for-Profit Corporations Act, works, is only accessible through members and is only applicable to the 3 disciplinary outcomes. But yes, the appeal process laid out in the policy deals with outcomes of investigations.
Great answer. All right, the last question here. As an infrastructure owner, if we see a private homeowner digging near our infrastructure without locates, what is the course of action?
That's a great question. I've answered the last few, so Corey, over to you.
So we would actually encourage members to reach out if they're seeing excavators digging without locates. We would ask that you submit the request or the complaint, through our complaint portal. There is an option to submit it anonymously as well. This is the only contravention that we accept anonymous complaints. That being said, you still are required to add your contact information so that we could reach out. However, your name will not be included in the complaint to the excavator. And yes, like Ryan mentioned earlier, we take these matters very seriously because they are a huge risk to public safety. So yes, we definitely encourage that. Thank you.
Keegan, thank you for those questions. If there's any more to come, we will respond to every question that's posted. And for the audience, if you think of a question later, perhaps over not during the webinar, please don't hesitate to reach out to us. It's important for us to communicate our processes and to be supportive. I'm recognizing that this is our last webinar of the season. I want to say thank you for the support that to the community that you've given to us. We've seen that in our recent request for changes to our funding model. We've seen that in the one-on-ones that have come to that we've handled during the CAPE team. So thank you for your support. We have a very busy year to come. So if there are any topics that you would like for us to cover in a future webinar, please let us know either by emailing us at CAPE or by dropping it into the comments. And with that, I think I'll leave the last to Jean Lepine. Jean, do you have any final comments?
Oh, that was a setup. I do, and I thank you, Ryan, and thanks everyone again for making the time. I wanted to point out that we've got a very positive working relationship with the ministry and that we continue to collaborate with them on all of this good work, right? Because we really are partners and hopefully trusted advisors, but we do work hand in hand, and we from kind of the public safety administrative authority side of things, we try to do the best that we can with the resources that we've got. We really count on the collaboration of industry and all of you. But we do work very closely with the ministry. And so when you find yourself in situations where you want to share something with the ministry, you know, a thought, a proposal, a recommendation, do feel comfortable sharing it with us as well, because it makes us better. It really does. It prepares us. It makes us think. And so I encourage you when you are doing that kind of work to share it with us as well, because we will take it on board and we'll think it through, and it'll make us better over time. So thank you for the opportunity. Thank you for taking compliance seriously. It's it's important. It keeps people safe and it gets projects moving. So thank you. Happy
Well-
holidays. Happy holidays.
Well, let's end it there. Thank you very much, Jean, Corey, and Keegan. Thank you very much for your support and for your contributions to the webinar today. Have a wonderful and safe holiday season ahead. Thanks very much, everyone. Take care.
Happy holidays.